Okay, let's unpack this. We often talk about professionals, engineers, doctors, lawyers, geoscientists, and we immediately think, specialized expertise, right? High level of skill.
Right. That's the immediate association, technical chops.
But if you kind of strip away the degree for a second, the technical competence, what really makes a professional different from, say, a highly skilled technician or someone in a specialized trade? It feels like there's more to it than just knowing how to do complex stuff.
There absolutely is. It's the moral dimension, the technical skill. As you said, that's the baseline. It's essential, obviously. But the real defining characteristic, it's accepting this profound public trust.
Public trust. How does that manifest?
Through a distinct, legally enforceable ethical code that governs their conduct. That's the linchpin. This code takes their specialized knowledge, which could just be a personal asset to sell, and transforms it. It becomes a public service they have a duty to manage responsibly.
Okay, so that's our mission for this deep dive. We're really getting into this foundational idea that defines professional status, especially here in Canada, where self-regulation is such a big deal.
Exactly.
We need to understand why these codes are even a thing, how they're structured, especially when duties might clash, and what it truly means when we say professionals must hold paramount the safety, health, and welfare of the public. This is the bedrock, the contract.
It absolutely is. And, if you're navigating these foundational legal and ethical requirements, maybe trying to get ahead in your professional journey, and especially if you're studying for the National Professional Practice Examination, the NPPE, well, subscribing now is probably a good idea.
Right.
This deep dive, it's going to give you that crucial analytical context, the legal background you really need to grasp these core concepts inside and out.
So let's start there. The source material really hammers this point. The existence of this distinct ethical code is the critical feature separating a profession from a trade or occupation. Why does one document hold so much weight?
Well, because the code formalizes this commitment. It's a commitment to accountability, to public service. That goes way beyond just, the immediate job or the contract.
How so?
Think about it. A skilled tradesperson is primarily accountable to their client or maybe the specifics of the contract. A professional, though, through the code, accepts this unwavering commitment to ethics. And that commitment obligates them to society as a whole, not just the person paying the bill.
Because their work has wider consequences.
Monumental public consequences. Designing a hospital, certifying a geological survey for resource extraction, defending someone in court. These actions ripple outwards. The code acknowledges that power and demands it be used responsibly.
It's a really profound difference when you frame it like that. It's not just knowing how to build the bridge, the technical engineering skill.
Right.
It's having this inherent moral responsibility for everyone who might ever use that bridge for its entire lifespan. It forces the professional's focus beyond the project specs, beyond the deadline, to the broader public good.
And that commitment, that promise, is precisely why Canadian society grants these groups this unique status.
Self-regulation.
Okay, self-regulation. Let's pause on that because it sounds powerful. It's a major legal and moral status. Yeah.
Huge. Through provincial and territorial laws, specific professions, engineering, geoscience, medicine, law, are the classic examples. They get the autonomy to set their own standards, manage who gets in, define how practice should happen, and crucially, discipline their own members.
Wait a minute, though. Let's push on that. Doesn't that immediately raise a red flag? A sort of maybe cynical conflict of interest question. If the regulatory body, like, say, PEO in Ontario or EGBC out in British Columbia, is run by the professionals themselves, how can the public be truly confident they'll crack down hard on their own peers, especially when, money or reputation might be on the line?
That's an excellent question. It's the critical question, really. And the answer lies in that public trust we mentioned. It's the only currency this system runs on.
So the trust has to be earned constantly. That autonomy, the privilege of self-regulation, it isn't handed out lightly. It's entirely based on what we call the moral contract or the social contract. Society grants this freedom only because these professions promise, explicitly through their codes of ethics, to place the interests of society and the public welfare above their own interests, or their colleagues' interests, or their clients' financial interests.
Okay, so the code isn't just internal rules, it's the guarantee to society.
It's the legal collateral, if you will, securing that contract. If the profession fails to uphold the code, if that trust gets broken repeatedly or egregiously, the government can step in. And sometimes, historically, it has revoked or significantly curtailed that self-regulatory privilege.
Got it. So the stakes are incredibly high for the profession itself to enforce its code rigorously.
Precisely. And this leads us right into another really crucial distinction, one that often trips up people entering the profession: the difference between ethics and the law.
Right, we touched on this. Law is the floor, the minimum acceptable standard. Ethics is the ceiling, the ideal. But let's make that more concrete. What does that mean day to day, especially in those tricky gray areas where a technical decision has ethical weight?
Okay, think of it like this. The law tells you what you must do. Often it's about explicit rules, regulations, statutes. If you break a law, there's usually a defined consequence.
Get our cut, mostly.
Mostly. Ethics, on the other hand, guides what you should do. It comes into play especially when the law is maybe silent on an issue, or it's ambiguous, or frankly, maybe the law hasn't caught up yet and feels insufficient. A professional's responsibility always stretches into that ethical space beyond the legal minimum.
Can you give us a specific example where that gap exists?
Sure. Let's take environmental impact. Imagine a project that technically meets every single legal requirement for air quality standards. Check, 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 the law is satisfied. But what is the professional involved, say an engineer or geoscientist, knows from newer research, or maybe specific local factors like a vulnerable population nearby, that even though it's legal, the design will still likely lead to foreseeable public health problems down the road, problems the current law doesn't address yet.
So legally compliant, but potentially harmful.
Exactly. Their ethical responsibility under the code's duty to public welfare compels them to act. They need to flag it, probably revise the design, maybe advocate for stricter controls, even if it costs more or delays the project. Legal compliance is just the starting point. The ethical code demands their best judgment aligned with the public's well-being.
So being bound by that code means you've essentially signed up voluntarily for obligations that go beyond just ticking legal boxes. It's about conscience and duty.
That's it. You've accepted a higher standard, guided by the code, which supersedes merely following the letter of the law.
Okay, that makes sense. Now, you mentioned history earlier. These codes didn't just appear out of thin air.
Not at all. To really appreciate the legal weight these codes carry today, especially in Canada, you have to look back. The basic idea, people with special knowledge holding themselves to certain standards, that's ancient. You see whispers of it in things like the Hippocratic Oath for doctors, right? Or promising to act for the patient's benefit. Even medieval guilds had moral standards.
But for the modern professions we're focused on, like engineering and geoscience in Canada, it wasn't quite so philosophical in origin.
No, it was far more reactive, unfortunately. The establishment of legally recognized, enforceable ethical codes was, in large part, a direct response to catastrophic failures. Tragedies.
Right. This is the crucial historical context. The codes were often born from disaster, which showed everyone in the worst possible way that highly specialized technical skill without strong ethical oversight is actually dangerous.
Terribly dangerous. And two specific Canadian events really stand out as catalysts for cementing these ethical mandates into law for engineers and geoscientists. First, the Quebec Bridge collapse in 1907.
A notorious failure.
Absolutely. It was a massive disaster, caused primarily by technical errors, fundamental design flaws, calculation mistakes. But the inquiries afterwards revealed it was tragically compounded by ethical failures.
Like what?
Poor communication between engineers, intense pressure to rush the construction, and critically, a clear failure by some senior engineers to heed warning signs, to exercise independent judgment, maybe even a lack of moral courage to speak up forcefully when things started to look wrong. It was as much a failure of ethics and responsibility as it was a failure of physics.
And much more recently, we had the Elliott Lake Algo Center Mall collapse in 2012.
Another heartbreaking event. And again, yes, it was a structural failure, rust, corrosion, technical breakdown.
Yeah.
But the subsequent investigation, the inquiry led by Justice Belanger, painted a devastating picture of the ethical failures that allowed it to happen.
Negligence.
Negligence, yes. Reports of inadequate inspections over the years, poor judgment shown during repairs, a troubling pattern of downplaying or ignoring warning signs that were apparently visible, a fundamental breakdown in the duty of care owed to the public who used that mall.
So these weren't just accidents. They were seen as betrayals of the professional responsibility.
Exactly. These events, and others like them, starkly demonstrated to society and to governments that self-regulation couldn't just be a loose agreement based on technical skill. It had to be legally anchored to ethical vigilance. These tragedies created the political will, the public demand, for legislatures across Canada to strengthen the legal framework.
They essentially told the professions, okay, you can govern yourselves, but your ethical code isn't optional. It must be part of the law, and you must enforce it rigorously to prevent this kind of moral drift that leads to disaster.
Precisely. And that brings us squarely to the code's legal status today. It's not just a set of nice ideas or association guidelines.
No, it's embedded in law. This is critical for anyone preparing for the NPPE to understand.
Absolutely vital. The Code of Ethics is non-negotiable because it's written right into the foundational provincial and territorial legislation, the main acts governing the professions, and often detailed in the accompanying regulations.
Can you break that down, the difference between the Act and the regulations?
Sure. Generally, the Act is the primary statute passed by the legislature. It establishes the profession's right to self-regulate, defines who can practice, like using the title professional engineer or PM, and sets out the broad mandate of the regulatory body, its duty to protect the public interest.
Okay, the overarching law.
Right. Then the regulations, which are created under the authority of the Act, provide the detailed rules and procedures. And typically, the specific code of ethics, the list of duties and principles, is found within these regulations. And crucially, regulations have the full force of law, just like the Act itself.
So let's make this concrete for listeners who might be dealing with different regulatory bodies across Canada.
Okay. If you take Professional Engineers Ontario, PEO, the Code of Ethics is right there in Regulation 941, made under the Professional Engineers Act. It spells out duties like holding public safety paramount, acting with fairness and loyalty, upholding the profession's honor, and the duty to report unsafe or unethical situations.
And out west.
In British Columbia, Engineers and Geoscientists British Columbia, or EGBC, enforces its code through the framework of the Professional Governance Act. The specific code provisions detail duties related to integrity, competence, public safety, environmental stewardship, and critically, they define breaches of these duties as professional misconduct, triggering disciplinary processes.
And Alberta.
APEGA, the Association of Professional Engineers and Geoscientists of Alberta, similarly has its binding ethical principles laid out in its general regulation under the Engineering and Geoscience Professions Act, again covering duties to the public, employers, colleagues, and the profession. The structure is remarkably consistent across the country.
So the bottom line is, if a professional violates one of these ethical duties, maybe they fail to disclose a conflict of interest, or they sign off on something they haven't properly reviewed.
That's not just considered bad form or poor judgment. It's formally defined in the legislation as professional misconduct.
And that term professional misconduct has specific legal weight.
It absolutely does. It's the trigger for the formal disciplinary process within the regulatory body. The system is designed to take ethical failures out of the realm of mere opinion and define them as clear breaches of the legal and social contract the profession holds with the public.
Okay, so when an allegation of misconduct arises, the regulatory body doesn't just make a snap judgment. There's a process.
A very rigorous one, grounded in legal principles, specifically the principles of natural justice.
Natural justice. That sounds important, but maybe a bit like legal jargon. What does it actually mean for the professional involved?
It essentially means fairness in the process. Natural justice rests on two main pillars. First, the right to be heard alterum partem, as the lawyers say. The professional facing allegations must be given proper notice of the claims against them. They have the right to know the case they have to meet, the right to present their own evidence and arguments, often the right to cross-examine witnesses, and usually the right to have legal counsel represent them.
Okay, so they get a full chance to defend themselves.
A full and fair chance. The second pillar is the rule against bias nemo judex in causa sua. The people making the decision, the disciplinary panel or committee, must be impartial. They can't have a personal stake in the outcome or prejudge the case. This ensures the decision is based only on the evidence presented during the hearing, according to the standards set out in the Code and the Act.
So even when investigating a serious ethical breach, the process itself has to be legally sound and fair.
Absolutely. It has to be defensible, potentially even in a court of law if the decision is appealed.
And let's talk about the consequences. If, after this fair process, a professional is found guilty of professional misconduct, what happens?
The consequences, the sanctions, can be severe. They're designed primarily to protect the public, maintain the integrity and reputation of the profession, and deter future misconduct.
What kind of range are we talking about?
It can range from, say, a formal reprimand that gets published to fines, to requirements for the professional to take specific courses or undergo supervision for a period. It could involve restrictions on their practice. Then you get into more serious sanctions like suspension of their license for a set time.
Meaning they can't practice during that suspension.
Correct. And the ultimate penalty is revocation of the professional license. This means they lose their legal right to practice that profession entirely, effectively ending their career in that field, in that jurisdiction. The code, backed by this legal framework and disciplinary process, transforms ethical ideals into legally enforceable standards, which is fundamental to maintaining public confidence.
Okay, that clarifies the legal bite behind the code. Now let's look inside the document itself. You mentioned the structure is quite consistent across Canada. This hierarchy of duties, that seems key.
It's absolutely key, especially for navigating those difficult situations where duties might seem to conflict. The structure isn't just a random list, it's intentionally hierarchical. It reflects the professional's different moral relationships to the public, to their client or employer, to their colleagues, and to the profession itself. And it tells you which relationship takes priority.
And right at the top, always number one, is the duty to society and the public.
Always. It's the apex, the supreme obligation. Every single code, in slightly different words perhaps, states that the professional must hold paramount the safety, health, and welfare of the public.
Paramount. That word carries a lot of weight.
It means supreme, overriding. Nothing else, not client demands, not employer orders, not personal gain, not even loyalty to colleagues can legally or morally supersede this duty. And it's increasingly interpreted broadly now, encompassing not just immediate physical safety, but also things like long-term environmental stewardship, considering public health impacts, promoting sustainable practices.
So going back to the bridge example, or maybe a dam, the engineer's primary paramount duty isn't just to the company paying them to build it or its shareholders.
No.
It's to the people downstream, the ecosystem, the long-term public safety and environmental integrity of that region.
Precisely. You can think of the public interest as the ultimate client. This really underpins that public fiduciary framework we talked about. The professional is entrusted to act in the public's best interest, especially if it conflicts with the immediate financial or commercial interests of the party who hired them. It's what ensures the profession serves humanity first, not just commerce.
And this paramount duty, it must be the source of the most challenging ethical dilemmas professionals face, right? Because it forces you to see the ethical dimension in every technical choice.
Absolutely. And that tension becomes really clear when we look at the next level down in the hierarchy. Duty 2, the duty to employers or clients.
Okay, this is also crucial, obviously. You need to serve the people who hire you.
Of course. Commerce and practice depend on it. This duty requires things like honesty, integrity, competence, and fidelity towards your employer or client.
This is where the more day-to-day professional obligations live.
Yeah.
Like keeping proprietary information confidential.
Yes, maintaining confidentiality is a big one. Also, acting faithfully, avoiding conflicts of interest, or disclosing them fully if they arise, being honest about your capabilities and the limitations of your work, avoiding any kind of deception or misrepresentation in reports, data, or billing. These are all critical.
But, and this seems to be the crucial point, this duty, while important, is explicitly and legally subordinate to that paramount public duty.
That is the absolute key takeaway about the hierarchy. Subordinate. The professional is, in effect, serving two masters, the client, employer, and the public. But the code clearly dictates which master has ultimate authority when their demands conflict.
Okay, I want to push back on this a little, practically speaking. If a professional consistently puts the public interest, as they interpret it, ahead of their employer's direct instructions or financial goals, aren't they just going to get fired? The code sounds noble, but doesn't the reality of needing a paycheck create this massive pressure to compromise?
It creates enormous pressure. You're absolutely right. And that pressure point is precisely where professional ethics meets the road, where moral courage is genuinely tested. The regulatory bodies, the codes themselves, they acknowledge this inherent tension. By providing explicit authority, both moral and legal, for the professional to make that difficult choice. If an employer directs a professional to do something that compromises public safety, say, use a cheaper substandard material to cut costs on a critical structure, the code doesn't just allow the professional to refuse, it requires them to refuse.
even if it costs them their job.
even if it puts their employment at risk. The duty to public safety and professional integrity under the code legally outweighs the duty of simple obedience to the employer or client in that specific conflict. The code essentially says your license, your professional standing, depends on making the right choice here, not just following orders.
And that refusal shouldn't just be a verbal no. It needs to be handled properly.
Absolutely. The professional should document their concerns clearly. They usually have a duty to be candid with the client or employer, explaining why the direction is unacceptable based on safety or ethical standards. They should try to resolve it internally first, escalating it up the chain if necessary.
But what if that fails? What if management digs in?
If internal resolution fails and the public risk remains, the code generally mandates further action. This could involve reporting the situation to the client directly, if the employer is preventing that, or ultimately reporting the hazardous situation or unethical direction to the regulatory body itself. The regulator can then investigate and intervene, providing a layer of institutional backing that the individual professional might lack.
Okay, so the subordination principle isn't just theoretical. There are mechanisms, albeit potentially painful ones, to uphold it.
Correct. Now, moving down the hierarchy, we get to duties 3 and 4, which are more about the internal health and external reputation of the profession itself.
Duty 3 involves colleagues and subordinates.
Yes, this covers obligations like treating peers and those you supervise with fairness, respect, and good faith. But critically, it often includes an active duty of mentorship. Senior professionals have an ethical responsibility to help develop the competence and, importantly, the ethical awareness of junior members, interns, or engineers in training.
So it's about passing on the torch, ensuring the next generation understands and upholds the standards.
Exactly. It's how the profession maintains its integrity and competence over time. You're not just responsible for your own ethical conduct. You have a role in fostering it within the professional community.
And finally, Duty 4. The obligation to the profession itself.
This duty focuses on maintaining the honor, dignity, and reputation of the profession in the eyes of the public.
How does that translate into action?
It involves things like avoiding conduct that would discredit the profession, engaging in false or misleading advertising, making malicious statements about colleagues, competing unfairly. But perhaps the most challenging yet crucial element for self-regulation is the duty to report unprofessional conduct by others.
Ah, the duty to report your peers. That sounds difficult.
It is incredibly difficult, psychologically and sometimes professionally. But if a professional witnesses a colleague engaging in serious misconduct, maybe gross negligence, incompetence putting the public at risk, or a significant ethical violation like falsifying data, they generally have a mandatory ethical and often legal obligation under the code to report that conduct to the regulatory association.
And failing to report it is itself a violation.
Often, yes. Failure to report known, serious misconduct can be considered professional misconduct in its own right. This internal policing mechanism, while uncomfortable, is absolutely essential for the self-regulatory system to maintain public trust. It demonstrates that the profession is willing to address problems within its own ranks.
So pulling this together, the code isn't just a list of do's and don'ts. It's a structured framework for decision-making, and it's the engine driving accountability within this whole self-regulatory system.
Precisely. And because that power of self-regulation is delegated by the government, by society, the enforcement of the code has to be transparent and rigorous. Accountability is maintained through those formal investigation and discipline procedures we discussed.
Right, adhering to natural justice, ensuring fairness, impartiality, the right to appeal.
And the outcomes are key. As we mentioned, the decisions of discipline committees, whether it's a reprimand, a suspension, or a revocation, are typically made public.
Why is that public disclosure so important?
Transparency is the bedrock of public trust and self-regulation. Publishing these outcomes does 3 things. 1, it holds the individual professional publicly accountable for their actions. 2, it serves an educational purpose for the entire profession, clearly signaling what kind of conduct is unacceptable and will not be tolerated. And 3, perhaps most importantly, it reassures the public that the profession is taking its ethical gatekeeping role seriously, that it's willing to police its own ranks effectively.
Okay, so that covers the stick side of the code, the enforcement and accountability. But what about the guidance aspect? How does the code help professionals before things go wrong?
That's a great point. Beyond just being a basis for punishment, the code is fundamentally an educational and preventative tool. The goal isn't just to catch misconduct after the fact, it's to help professionals anticipate ethical dilemmas and foster what you might call ethical intuition.
Ethical intuition,
Yeah.
like a gut feeling for what's right or wrong in a professional context.
Sort of, yeah. But it's more than just a gut feeling, it's a developed sensitivity. It's about cultivating the ability to recognize the ethical dimensions of a situation almost instinctively, to ask the right questions early on, to foresee potential conflicts or harms before they fully materialize. The code provides the framework and the principles to help develop that sensitivity.
And how does that differ from, say, a standard corporate ethics policy you might find in any large company?
That's a really important distinction. Most corporate ethics policies, while valuable, are primarily focused on internal compliance, mitigating legal and financial risks for the company, and ultimately protecting shareholder value. They serve the interests of the business.
Okay.
The Professional Code of Ethics, because it's tied to licensure and self-regulation, operates within that public fiduciary framework we keep coming back to. It mandates that the professional's judgment must ultimately serve the benefit of the public, the potentially vulnerable party, even if it goes against the company's immediate commercial interests. It elevates the professional's role beyond just employee. They become, in that context, a temporary guardian of the public interest related to their expertise.
Which is why, for our listeners studying for the NPPE, really internalizing this framework is so vital. It's not about just memorizing rules for an exam.
Absolutely not. It's about adopting the ethical mindset that the code represents. The NPPE tests understanding of these principles, yes, but the real goal of the code in professional formation is internalization. Meaning that true professionalism isn't just about knowing the rules, it's when acting ethically becomes almost second nature. When the principles of public safety, integrity, competence, and fairness are so deeply embedded that they instinctively guide your decisions, even under pressure. That requires ongoing reflection, continuous learning, and sometimes real moral courage to uphold those principles when they're challenged.
Okay, let's make this really practical. Imagine a professional facing a tricky ethical situation right now. How do they actually use the code to move from, this feels off, to a justifiable course of action? Let's walk through that, maybe using the kind of systematic decision-making process outlined in the source material.
Good idea. Let's use a hypothetical. Say an engineer working on a large infrastructure project notices that some of the required quality assurance checks on critical components, let's say concrete pours for supports, are being skipped or rushed to keep the project on an extremely tight, maybe unrealistic schedule.
Okay, so step one, recognize the ethical issue and identify the stakeholders.
Right. The issue is clearly a potential breach of quality control standards, which directly impacts structural integrity and therefore public safety. The stakeholders are numerous: the future users of the infrastructure, the client paying for the project, the employer, the construction firm or consultancy, the regulatory body that issued the permits, the public at large, other professionals on the team, and the engineer themselves and their professional obligations.
Step two, consult the relevant clauses in the Code of Ethics.
Immediately, Duty 1 jumps out. Hold paramount the safety, health, and welfare of the public. This directly overrides duty. Two concerns like meeting the employer's schedule or budget targets if safety is compromised. Other relevant clauses would likely include duties related to professional competence, ensuring work is done correctly, integrity, not signing off on or accepting substandard work, and possibly the duty to report hazardous conditions or practices.
Step three, evaluate the potential courses of action. What are the options and what are the likely consequences regarding fairness and safety?
Option A. Ignore it. Hope for the best. Clearly unethical, violates paramount duty, potential for disaster. Option B. Raise the issue informally with the site supervisor. This might be the first step, but what if they brush it off due to schedule pressure? Option C. Formally document the skipped checks and report them in writing to the supervisor and project manager, referencing the code's requirements. Option D. If internal reporting yields no corrective action, consider escalating it perhaps to the client's representative, or even preparing to notify the professional regulatory body. The evaluation has to weigh the effectiveness of each option in actually correcting the safety risk versus the potential professional or personal fallout.
Step four, decide on the course of action that best aligns with the primary duty, the public interest.
Given the paramountcy clause, the decision must prioritize rectifying the safety risk. This likely means starting with clear internal reporting, option C, demanding that proper QA procedures be followed immediately, and potentially refusing to sign off on work affected by the skipped checks until they are properly done. The chosen action has to demonstrably uphold the public safety duty above schedule or cost pressures.
And finally, step 5. Document everything. The rationale, the actions taken, the communications.
Absolutely critical. Record dates, times, specific observations, who was spoken to, what responses were received, what corrective actions were taken or not taken. This documentation serves multiple purposes. It creates a clear record for the project, it protects the professional by showing they acted responsibly, and it provides the necessary evidence if escalation, like reporting to the regulator, becomes necessary.
That structured approach seems essential for navigating complexity. And it leads us to what might be the ultimate ethical stress test for a professional whistleblowing scenario.
Yes, this is where the hierarchy of duties faces its sternest challenge. It pits that paramount duty to the public directly against loyalty to the employer and often the professional's own financial security and career path.
So let's take that same engineer. They recognized the skipped QA checks. They reported it internally following the proper steps. Maybe they even escalated it to senior management. But management explicitly tells them to back down, maybe citing huge cost overruns if they delay, possibly even threatening their job if they push the issue further.
This is the nightmare scenario. The engineer has tried internal remedies, but the organization itself appears willing to tolerate or even endorse a practice that compromises public safety. Now what?
What does the code demand?
The code, by prioritizing public welfare, provides the moral and often legal authority, indeed the obligation, to act further. Having exhausted internal channels, the professional's duty likely requires them to escalate the concern outside the organization. This is whistleblowing.
Who would they report to?
It could be the ultimate client, if they weren't involved in the decision, the relevant government permitting or safety authorities, or, very commonly, their own professional regulatory body, like PEO, APEGA, EGBC. The regulatory body has the mandate and the power to investigate such serious allegations and compel compliance.
But the personal risk is immense.
Immense. Whistleblowers often face retaliation, ostracization, career damage. That's why moral courage is so vital. However, knowing that the Code of Ethics supports, and in fact mandates, this action in extreme circumstances provides crucial backing. Increasingly, legislation also offers some protection for whistleblowers, though the reality can still be very difficult. The professional acts not out of malice, but out of fidelity to their highest ethical duty.
So the code provides the justification, even if the path is hard.
It provides the ethical and legal framework, but we have to be realistic. The codes aren't perfect magic wands. They operate in a world full of ambiguity and pressure.
What are some of those common challenges professionals face when trying to apply the code?
Well, ambiguity itself is one. Sometimes principles within the code might seem to conflict in a specific situation. Economic pressure is huge. The constant drive to do more with less, faster, cheaper, can create temptations to cut ethical corners. Globalization adds complexity whose standards apply when working across borders.
And now, maybe the biggest challenge, rapidly evolving technology.
Absolutely. Artificial intelligence in design and decision-making, massive data sets raising privacy concerns, autonomous systems controlling critical infrastructure. These technologies raise ethical questions the original framers of the codes couldn't possibly have foreseen.
So how do professionals handle that?
They have to rely on interpreting the spirit of the code, not just the literal text. What are the underlying timeless principles? Integrity, competence, diligence, fairness, and above all, protecting the public welfare. They need to apply these core ideals to novel situations, using their best professional judgment and often engaging in dialogue with peers and the regulatory body. It demands continuous learning and critical thinking.
Which really underscores your final point. The code isn't static. It has to be a living document.
It absolutely must evolve. Society's expectations change. Technology creates new possibilities and new risks. Our understanding of welfare expands. The codes have to adapt to remain relevant and maintain public trust.
And we've seen that happen, right?
Definitely. If you look at recent updates to codes of ethics across Canada, you'll often see new or strengthened clauses addressing issues that weren't prominent decades ago. Explicit duties related to environmental stewardship and sustainable development are now common. Principles regarding equity, diversity, and inclusion are being integrated, recognizing that ethical practice extends beyond just physical safety to encompass social responsibility and fairness.
So the professional commitment itself grows and adapts over time. It's an ongoing dialogue between the professions and the society they serve.
Exactly. It's a dynamic contract, constantly being renegotiated and refined to meet contemporary needs and values.
Okay, let's try to synthesize this. We've covered a lot of ground. From the fundamental definition of a professional to the nitty-gritty of enforcement, what's the main takeaway?
I think the central theme is that the code of ethics is so much more than just a list of rules. It's really the heart, the soul of professionalism. It's the mechanism, legally enforceable, that transforms specialized technical knowledge from a mere skill into a public trust.
And that technical competence alone, while necessary, is simply not enough.
Not enough. The essential defining quality is that ethical commitment, the willingness to act with integrity, maintain competence, exercise independent judgment, and crucially, to always prioritize the public safety, health, and welfare above all other considerations, including self-interest or commercial gain.
And as technology keeps accelerating, as global challenges mount, the ethical judgment required from professionals is only going to become more critical, more complex.
No question. Which leads to maybe a final provocative thought for you, for our listeners, to mull over, building on that idea of the living document. Given that these ethical codes must keep adapting to things like AI, climate change, social equity demands, what do you think is the next major societal value beyond the safety, diversity, and sustainability we're grappling with now that will likely need explicit recognition, explicit codification within professional ethics to maintain that vital public trust over the next decade or so?
That's a big question. Maybe something around data ethics, algorithmic fairness, or perhaps the ethics of influencing behavior through technology.
Could be any of those, or something else entirely. It's something professionals, regulators, and society need to be thinking about proactively.
Absolutely. Well, internalizing these principles, understanding this whole professional contract we've discussed today, it's clearly fundamental for success, especially on the NPPE exam.
Key to success, definitely.
So subscribe now for more deep dives like this, continued guidance, and the support you need to really understand these concepts and be successful in the NPPE exam.